Good morning. I believe we're recording, and today is June 8th. This is the Vermont Labor Relations Board. This morning composed of Michelle Phelps, Karen Sodek, and myself, David Boulanger, is chair. It is June 8th. The matters under consideration today are 2303, the grievance of Scott Crowley regarding classification review, and 2304, again, regarding classification review of probate registers. As preliminary matters, I would note that Exhibit G in 2304 is not color-coded. We have copies in black and white and perhaps a shade of gray. We would ask subsequent to the hearing that we get color-coded copies so that any explanation of that exhibit, which tracks the color coding, is easier for the board to consider. First,
Mr. Chairman,
yes.
Just on that, do you want or prefer that be electronic or hard copy, or both?
Paper copies, hard copies, please.
Okay.
All right.
Thank you.
All right. And in regard to appearances today, I see Mr. Belcher and Ms. Powers. Mr. Belcher, anyone in addition for the union?
No, but there are some of the members who have logged on to watch, but I'm the only representative.
I understand that. And for the state, Ms. Powers.
Hello, I will also be having some colleagues that might come in to just observe.
Thank you. As a preliminary matter, we want to hear briefly from the parties regarding the state's motion to exclude Exhibit G, which is a fact-finder's recommendation by Michael Ryan, and also in regard to Exhibit 1. Ms. Powers.
You'd like me to start with that?
In regard to the motion to exclude Exhibit G.
It's Exhibit Q. But you want me to
I'm
present
sorry.
my argument first about it?
Yes, just briefly in regard to, it's the exhibit regarding the fact finder's report by Michael Ryan. Are we in agreement about the substance? Perhaps the letter is different.
Yes.
And I just want to clarify, ours is also Exhibit Q as well.
Yeah. All right.
I think, first of all, there's not actually a dispute about whether to add the state's proposed Exhibit 1 to the record, the attachment to that motion. I believe the union consented to that in their response. And then as far as Exhibit Q goes, I also think that the parties seem to agree that Exhibit Q, the fact finder's report, is not appropriately considered part of the record below in the probate registers case, because it was not specifically considered or referenced during the classification review or the Step 2 grievance review. But I want to make it clear to the board that the state does agree with the point VSEA made that parts of this fact finder's report could be informative to the board for both of these cases, not just the probate registers case, but also for the Crowley grievance. In terms of understanding the board's jurisdiction, the remedies available, the changes that were made to Article 15 of the CBA and why and how those changes were made, I think it speaks to the bargaining history that could be informative to the board to the extent that the plain language of the CBA is not clear on its own. So the state defers to the board about how to handle this in regards to the official record of the classification grievance. The CBA is pretty clear about what constitutes the record below, and the parties seem to agree that Exhibit Q was not part of the record below. But if the board wants to admit Exhibit Q into evidence in any capacity, I don't know if you would need to admit it into evidence in order to consider it when evaluating Article 15. But to the extent that the board might want to admit Exhibit Q, the fact finder's report, into evidence, the state really just requests that it's clear that it's only admitted for the narrow purpose of interpreting the contract language and not for the purpose of determining whether the classification review was arbitrary or capricious.
Thank you. Mr. Belcher?
It sounds, I'll be cautiously say that it sounds as though we're actually in some agreement on this. The parties throughout this case, including below and in the briefs, have debated the meaning of the contract and the history, and have even in both briefs quoted the fact finder's report. The issue initially arose with the HR manager at one of his lower initial filings, making representations as to the intent of the parties in supposedly negotiating to give wholesale authority to him to make these decisions in any way he seemed fit. Those are my words. And that was discussed, and then the issue arose again in the briefing and actually in a conference yesterday with the executive director and with counsel about remedial authority. And so there are those two issues. Now we agree that that your decision on the merits is limited to reviewing the record of what was considered below and admitted, and to determining whether or not there was the decision was arbitrary and capricious, whether or not their actions were arbitrary and capricious in reaching that decision. You have a separate role, however, of interpreting the contract, and you're allowed, I think you're empowered to look beyond the record to be able to make that kind of determination of what the contract means, not what the merits, I mean, they're not relevant specifically to the merits of the facts determined below, but in terms of interpreting the contract. In the discussion yesterday, there was reference to Tim Noonan's book. That's also not in the record. And looking at the contract language and the issue of remedy, you might need to look actually beyond even the contract article and the fact finder's report to look at the entire article below, the entire contract below, and even the prior contracts and perhaps even the executive branch contract to be able to understand the relationship between all of these. Basically, the fundamental issue, and I'll just address that quickly since we're on it, is that the executive branch contract and really all the decisions that the Labor Board has made on these kinds of questions, reclassification decisions, have been based on the executive branch language that explicitly limits or eliminates really the board's authority to issue any kind of remedy. And the prior contract with the judiciary and the executive branch before 2016 also severely limited or curtailed any remedial authority. The current agreement is based on a fact-finding report that was issued after extensive hearings, 4 days of fact-finding hearings, which is pretty unusual, I think, in Vermont, that were largely focused on this reclassification provision. And the fact finder drafted an entirely new procedure. And both parties made their case about either there should be some kind of explicit remedial authority, or there should be the limitations that were placed in the original contract. And the fact finder left that question, didn't include any language one way or the other about remedial authority, which puts it in the same position, we believe, as every other contract, which is that the board, as a part of its inherent authority, has the right to issue a remedy if it finds a violation, absent some kind of specific limitation in the contract. There is no limitation, no explicit grant of authority to remedy any other grievance in this contract. The grievance procedure doesn't include one. And so we believe that since there's no limitation on it, you have the right to issue a remedy. So that's one of the issues that's in dispute. The other deals with the general sort of intent of the new language, and I will defer that into my opening statement until I'm in the actual statement to go through some of that history with you. But I think that it's appropriate for you to be able to look at the fact finder's report. It may be necessary for you to also look at the full contract, and even perhaps the prior contracts if we get into that kind of dispute. On the remedy question, I'm happy to defer that until we see whether you find a violation and perhaps bifurcate that. But I do think that you have the authority to, and you have a need to be able to look at the fact finder's report. It's not a document that's readily available online or in the library that you can take judicial or administrative notice of. So that's why we offered it to you as an exhibit.
Anything further, Ms. Powers?
Well, I want to respond to Attorney Belcher's suggestion of if the board of bifurcating the issue of the remedy, because I do think that if the board finds a violation here and needs to determine what an appropriate remedy is, I feel there would be a benefit to the parties being able to fully brief this issue and perhaps present evidence to the board, because this issue wasn't flagged when the grievance first came up. So it's not fully briefed in the briefs that you have before you right now. And so I think that rather than place too much emphasis on the remedy issue right now, we can wait to see if there's a violation where the board will need to determine an appropriate remedy. And then I don't mean to kick the can down the road, but it is a much bigger issue if we need to actually argue about what an appropriate remedy is here.
I understand. Mr. Belcher?
No, that's fine. Thank you.
All right. The board's going to take a brief caucus.
Before we do, if I may, Mr. Chair, Attorney Belcher, could you confirm the representation by Attorney Powers that the union does not oppose including Exhibit 1 in the record?
Yes, that's true. I think I said that in my response, and it's true now too.
Thank you.
Yeah. back on. First, State's Exhibit 1 is in, since there is no opposition. And secondly, in regard to the fact-finding report, the board understands that it is not part of the record below, but also is cognizant of the discussion on both sides that use of the fact-finding report may be helpful in understanding the matter. And in general, it seems to me that both sides have submitted relevant portions of the fact-finding report in briefs prior, so that we have those parts of it already. And we agree that some discussion of the fact-finding report may inform the board's discussion of the matter as it proceeds to rule on these cases. Is that clear enough?
Thank you.
All right.
I would ask for one clarification. So is the fact finder's report in the record here, or are you just acknowledging that the board might refer to it and that we can refer to it?
The latter is the case. What we acknowledge is that the fact-finding report, and I think the parties agree, is not part of the record below.
Okay, thank you.
All right. That being the case, and there being no other preliminary matters, we'll proceed. Mr. Belcher.
Thank you, Mr. Chairman and members of the committee, of the board. So there are two cases, and both of them are the first appeals that have been filed since the parties adopted new contract language drafted by the fact finder and adopted by the parties back in 2016, I think. Most of and this may be the first reclassification appeal that these board members have heard. I don't know. There's been one since you folks have joined the board. But some history is probably in order, and many of the issues are common to both of these appeals. So I'm going to first talk about the issues in general, and then talk about the two specific cases. The new language in the contract was adopted as a compromise, as I mentioned earlier, after 4 days of fact-finding hearings that largely focused on problems within the existing reclassification procedure. The prior language had been involved a review of reclassification requests by a committee that was two members of management to one member of the union, or some ratio that was similar to that, but in any event, it was dominated by management. The process of reviewing was pretty cumbersome, and the appeal ultimately was basically to a committee that was established by the Chief Justice, and was dominated again by management. That had actually worked for some time. It had been pretty collaborative, but there had been frustration in recent years that the process had been skewed in favor of management, that the union had been excluded from some issues, and there was a desire to get a more standardized, more common, more and fairer system that could look at reclassifications. The fact finder, arbitrator Michael Ryan, put a lot of work into this. We really appreciated his efforts, and went in and drafted a new policy, a new process that gave each side something of what they wanted. Excuse me, some part of what they wanted. Initially, giving rather than trying to pretend that the union had some kind of meaningful input, In the initial phase, the arbitrator said, well, we'll just do what normally is done in these cases, which is that management will control the initial evaluation. But the idea was, and it was clear, that there had to be a record that was created, and that the record would then form the basis for appeals. And the appeal ultimately would be to you, to the labor board as a neutral body. And the appeal would be on that record. But the union would be entitled to submit materials up to that point that should be considered, and the standard of review would be the same as applies in the executive branch, which would be arbitrary and capricious. And as we discussed earlier, there was no explicit grant or denial of your authority to issue a remedy, as there is in the executive branch contract and as there was in the prior one. And we can discuss what that means later, but we submit that that means that you have the authority, as you do in every grievance, to issue a remedy. The basic principle is that the reclassification process is supposed to be guided by the Willis system. And I don't know how much experience you all have had with the Willis system. There was some hope that we could get a training for you before you had your first case. But I think the parties both agree that any training that would be provided while you have a case in litigation would be sort of impossible to separate from the litigation process. And so we'll do our best to explain it. I would say I'm not an expert in Willis. I have worked with these kinds of systems and with Willis somewhat. I hope that I can answer your questions if they deal with the Willis system. I'm going to try to explain it in broad strokes. My work on this case has been always in conjunction with Brian Morse, and also with others, including Margaret Crowley, who have greater experience than I do. If you have specific questions that relate to the Willis rating and the technical parts of it, I will ask for the leave, if it's possible, to get back to you on some of those, because Brian is not available today. And I expect that the same courtesy could be extended to the other side. I don't think that this case turns on the intricacies of the Willis system, but on the basic fact finding and the process that led up to the scoring, and that what we see as conduct that was arbitrary and capricious really occurred prior to the scoring process, and that the scoring process was necessarily skewed as a result of that. And so I think that we can discuss this, and I think that the briefs certainly have focused on what those kinds of issues are. But if this was just simply a matter of an argument about whether shading was done appropriately on one particular score, I would agree with opposing counsel that that's not a question, the kind of question that would rise to being arbitrary and capricious. But if the development of the facts was itself arbitrary and capricious, then the scoring of the resulting information necessarily has to be wrong and done over again. So the Willis system is an effort to help employers and employees develop and implement a job classification structure that's based on an objective analysis of duties that are actually performed by the workers who do the work, and that fit into an overall structure, a coherent overall structure of jobs, so that jobs relate to each other and are compensated in a way that that makes sense overall, hopefully is fair. An employee's pay shouldn't be based on whims of a manager or even the job performance of an individual employee, but on a rational and coherent system based on the work performed. While these kinds of systems predate Title VII and discussions and consciousness about comparable worth, the Willis system in particular was developed in response to specifically to discussions and legal fights about comparable worth and how to make sure that that work that was being performed in jobs that were traditionally dominated by women were not underpaid, but were rather paid appropriately in relation to their value in relation to other jobs in the system. I would urge you to actually take the time. I know that we've given you a lot of material, and the briefs pointed you to hopefully the parts of the record that that are most relevant. But I would urge you to take the time also to look through the Guide to Position Management, that the Willis system, that's at page 787 under tab J of the probate case, and also to look at the statement. It's a short statement by VSEA member, VSEA Vice President Margaret Crowley, at page 87 of the Crowley file. The two Crowleys are not related, but that discusses specifically how the Willis system has been applied to technology and to the nature of the technological changes that really both of these jobs or sets of jobs have had to contend with the introduction of new systems to both to handle hearings, but also to track cases, both the Odyssey and the WebEx system and other technological changes that have been introduced over the last several years. The fundamental idea of the Willis system is that the job should be evaluated based on a full understanding of the work, based really primarily and first and foremost on the employee's own records or reports as to what they do, and on questionnaires or interviews with the employees who are involved. The information should then be evaluated and rated according to several defined components and dimensions, including job knowledge, skills, mental demands, accountability, working conditions. The guide provides descriptions of the various dimensions within each level, and the rater is tasked with applying those dimensions and trying to come up with scores for the position. The rater or raters are also required to look at jobs in the context of the whole system, so that so the job that they're looking at will be placed in a coherent way in relation to other related jobs. And the analysis is intended to focus on the regular duties of the position, but also to give credit based on the higher levels at which a job is performed, so that if a particular task is performed as part of regular duties, even if it's not perhaps every day, or constant, but is a regular part, but is performed at a higher level sometimes than others, you look at the higher level. You don't look at the performance. You don't look at whether the employee's doing a great job or going well above and beyond in terms of the quality of the job, but you do look at the highest level of performance and shade or stretch the points to recognize that. Yeah, in the briefs, you have the actual an actual discussion at the end in each case about the scoring. I'm not going to go through the scoring, but if you have questions about that, I'll try my best to answer, but I may need to get help from Brian Morris after the fact. In both cases, however, our initial and most fundamental complaint has to do with the way that the facts were developed and the facts that were looked at by the judiciary. In both cases, our contention is that the judiciary was arbitrary and capricious in ignoring really anything that came from the employees themselves, and manipulating the information that they looked at and considered in order to justify denying the requested classifications. And the problems in the scoring flowed from there. In Mr. Crowley's case, he's employed as a court officer. My guess is that you have some sense of what a court officer does. They're the people who are generally in some kind of uniform and who deal with security issues, both in the building and in the courtroom itself. But he has been assigned substantial new duties over the recent years that overlap with other positions, including judicial assistant and some other positions. Those duties include keeping dockets, handling remote hearing systems, and other similar clerical duties or administrative duties that are not part of the normal duties of a court officer, but that are generally assigned to judicial assistants and others who are paid at a higher level, and paid at a higher level based on the new technology that's been introduced and that's been the subject of this. Another court officer was upgraded after she was assigned essentially the same work. Mr. Crowley is simply asking for recognition, similar recognition of his work. And several of his colleagues supported his statements as to the level of work he performed. The judiciary responded by claiming, we believe falsely, that the added duties were somehow temporary measures related to the pandemic. In one instance, they referred to the OA job being eliminated after he filed his forms, but the work itself had been assigned to him beforehand. So we believe that it's appropriate for you to consider that additional work related to the WebEx system. There's no indication that they are going to stop using him in the way that they've been using him. I'm not aware of any change since these materials have been submitted. The judiciary offers sort of a conclusory assertion that the added tasks are really just the same kind of work. And throughout, I think, both of the discussions, there's a suggestion or implication that the technology really maybe even lowers the skill of the work, though it's sort of equivalent to McDonald's or Burger King using replacing cash registers or cash with computer screens where somebody can just push a button, they put their finger on an icon that looks like a hamburger, and that's all they need to do. It's far from that to be far from the truth. There are manuals and so on, but these are complicated new duties that do involve a substantially different kind of work. Mr. Crowley wasn't interviewed, otherwise asked to provide facts related to this case. And the allegation that this assignments are temporary or that the work is somehow simple is really unsupported by any evidence in the record. And so we submit that was arbitrary and capricious and in violation of the contract's requirement that the judiciary abide by and follow the Willis procedure. The judiciary's approach to the probate register request for classification follows a similar pattern, but perhaps more severely. suspect that while you have some sense of what the work performed by court officers, you may or may not have ever had experience with a probate court. But it's somewhat of a world unto itself. The offices record and handle a wide variety of functions that are really basic to defining and recording fundamental rights to property and to person for the communities that they serve. Things like real estate property, adoptions, wills, estates, others, things like that that involve a fairly arcane set of laws and procedures that are different than what you see in the other parts of the judiciary, other courts. They're very important issues to the people they serve. In many cases, people are appearing in these offices pro se. They don't have lawyers. Somebody died and they need help how to handle the property, and they can't afford a lawyer. The probate courts were once part of county government and then were merged with the judicial branch fairly recently, perhaps 15 years ago. The judges are elected and often part-time, sometimes with very little real experience in the field. And while the managers of the courts exercise some formal supervisory role over the probate registers, the reality is that the registers themselves generally work very independently and are often, if not most often, the real experts in the matters that that are being addressed by the court, both in terms of history, process, and frankly, the law. They mostly, as they said in many of their statements that are in the record, they work most closely with judges and not with either the clerks or the comms, the court operations managers. But they are really central key professionals in managing this very important aspect of maintaining legal relations and rights within their counties. Since they were merged into the judicial branch, they've tried either as individuals or as groups to get upgraded to reflect their value to the willless system, and the judiciary has consistently resisted recognizing the value of the work that they do and upgrading them accordingly. They have consistently downplayed their role, suggesting over and over again that they're merely performing sort of low-level clerical functions based on clear instructions, and that the technological changes that have been made have really, if anything, de-skilled the work, which could not be farther from the truth. You can tell, I think, from reading their statements, and we would urge you to do that. We've quoted extensively from them in the brief, that these are intelligent and capable professionals performing really very important work at a high level. They prepared their initial request for review very methodically and comprehensively. The HR manager didn't so much as talk to or ask a question of a single register or to the judges who work most closely with them. No survey or questionnaire or interview was sent to the registers themselves. And in fact, not even all of the managers were questioned. Instead, the HR manager selected a small group of court administrators and clerks and sent them a, we think, loaded questionnaire designed to elicit information that would support the denial of the request. Since the HR manager didn't keep a record of this work, the union sent a public records request for all records and communications related to the decision, and those the materials we received in response are included in the file in the record. Records include some extremely troubling emails from managers who complained that they were being bullied or threatened to support management's decision to deny the request. One manager writing to another manager, presumably not knowing that the email would come to light, reported that the HR manager had said words to the effect that he could go to McDonald's and hire a new manager to replace her. We think predictably, the handful of managers who responded reported facts that the HR manager could use to fashion his argument. Having received those responses, the registers themselves wrote extensive reports rebutting those statements that are included in the file, in the record, and again have been essentially ignored by management. They also asked the judges to provide their perspective. The judiciary tried to get the judges to not respond, effectively interfering with the registrar's ability to collect evidence. Thankfully, some judges did respond and supported the registrar's statements as to the work they perform. You have in our brief and in the materials page after page of evidence rebutting or contesting the manager's efforts to minimize the work these registers perform. The judiciary has ignored the evidence that was provided, insisting that the new contract language gives them really unfettered and unreviewable discretion to pick and choose which evidence they're going to look at and to ignore evidence and cherry pick facts. This was not the kind of objective and comprehensive examination of facts that is required under the Willis system, and the scoring that resulted was predictably skewed. The HR manager successfully developed his own limited record that excluded ignored evidence of higher level functions that the employees perform, including things like writing orders for judges, doing research, answering questions, sometimes complicated questions or difficult questions for pro se litigants and others, and learning new technologies to track cases and handle hearings. And ignoring all of that created a picture of a low-level clerical worker simply filling out forms according to a manual. Process is insulting and demeaning, frankly, to these hardworking employees who serve as the backbone of this important office. And we submit that they deserve better and that a fair rating under the Willis system would result in a higher score and justify an upgrade. In closing, I would like to emphasize one point about the Willis system. It teaches and instructs that the decision should be based on information from the employees first, as much detail and breadth as is necessary to get a full understanding of the actual work that they do. Questionnaires are acceptable, but the guide talks about questionnaires completed by the employees, not their supervisors. That was, in fact, the process that was used by Siegel in reviewing the docket clerks after the contract was signed, the 2016 contract, not the supervisors. We don't have a problem with them looking to the supervisors as well, but the facts should be based on what the employees said. The entire point is to develop a system of compensation that is based on the work actually performed, not on some manager's preconceptions about what the work should be performed. Both the guide and the fact finder emphasize that the process should be non-litigious and collaborative, aimed at finding the facts and applying criteria. By substituting statements by managers and ignoring the facts presented by the employees. The judiciary basically has implied that these employees can't be trusted to tell the truth. And in fact, that the judges who supported them and the other managers can't be trusted as well. And that only these handful of supervisors who were asked can be trusted, because this is somehow, I guess, a battle between the employees and management. What we have in both of these cases is a management that refuses to even trust its employees and has in both cases substituted information for their word, the employee's word. In both cases, we ask that you find the judiciary's actions were arbitrary and capricious, and therefore in violation of the contract. And we would ask that you exercise your authority to issue a remedy, since the agreement does not waive that right, that inherent right, in order to have them upgraded as requested retroactively with full effect. Thank you.
Thank you, Mr. Belcher. Questions from the board? Ms. Saudak? Ms. Phelps? Executive Director Dillon?
Yep, I'm sorry. I have a clarification question regarding the Willis method. You may, I think you could probably answer it, but I just want a confirmation. Which I'm looking at the probate register case, tab J or exhibit J, which is the Willis Guide to Position Measurement. And I just want to make sure, looking at page 821, when it talks about the evaluation process, number 1, review documentation. I'll wait till you get there.
Well, you said 821, and my copy starts at 787. Oh, I see. Wait a minute. I'm sorry.
Yeah,
I'm sorry.
within
Yeah,
exhibit J.
I got it. I'm sorry. I apologize. I'm there now. Go ahead.
Okay, good. So, number 1 says review documentation, the written material, which should be an incumbent completed questionnaire, plus in some cases, a formal job description and / or interview notes should be read by each evaluator. In that sentence, the term incumbent completed questionnaire, the incumbent, does that mean the employee themselves, so the probate register themselves?
Yes.
Thank you.
Or Mr. Crowley.
Exactly, thank you.
Ms. Powers?
Thank you. Good morning again to you all. I'm going to begin my presentation by talking about the board's jurisdiction and authority here, specifically, just briefly as it pertains to the remedy in both cases. And then I intend to give an overview of the request for classification process as outlined in the CBA and the Willis classification system to supplement what Attorney Belcher just presented to you. Then to demonstrate how neither of these decisions that are being reviewed by the board were arbitrary or capricious, I'm going to go through each grievance chronologically. First, Mr. Crowley's RFR, and then the probate registers. Overall, the state's position in both of these appeals are pretty straightforward, that these cases are examples of the request for reclassification process that's outlined in Article 15 functioning as it's intended to. I'll be referring to the language in Article 15 a good bit during my presentation, and so for the board's reference, I just want to highlight for you that the text of this begins in the Crowley record at tab 1 at page 115. And then if you're looking at the record in the probate registers, it's tab J it's in tab J at page 893, it starts. Okay, so looking at the text of Article 15, and I'm looking at, it's page 117 of the Crowley record and 899 of the probate register's record right now. It states, it talks about this board's jurisdiction, and it states this board will decide the classification grievance based on the record of the proceedings below and determine whether the reclassification decision was arbitrary and capricious. There will be no hearing de novo. There's no further direction of authority given. And so the scope of the board's authority in these cases is just to determine whether the reclassification decisions were arbitrary and capricious. The agreed upon contract language does not give the board authority to determine specifically whether it thinks the judiciary's classification is correct or what Willis rating the board itself would assign to a position. And so this, I think, is particularly apparent when you look at what's in the binder as Exhibit Q, the fact finder's report. Page 9 of the report outlines VSEA's proposal during the bargaining that's related specifically to the changes that were going to be made to Article 15. And there were two major conflicts between the parties. First, VSEA proposed that this board would conduct a de novo review of the classification appeals, and also that the board be able to impose any remedy that it deems just. Pages 17 and 18 of the fact finder's report detail the judiciary's opposition to the board conducting a de novo review and the judiciary's disagreement to expanding the scope of the decision maker's remedial authority to just impose whatever remedy it deems just. The fact finder's recommendation, which was then agreed to be adopted by the parties, it's on page 38 of the fact finder's report. And he points out that if we're here to recommend a de novo review rather than an evaluation of the judiciary's decision under the arbitrary and capricious standard, a de novo review would go beyond the remedy that's available to state employees who are covered by different CBAs, particularly in the executive branch. And the fact finder said that he's reluctant to recommend in fact finding a benefit that other groups of employees have not yet received at the bargaining table. So it stands to reason that the fact finder also found it inappropriate to recommend the remedy that was proposed by the VSEA, which also would have gone beyond what other groups of employees received at the bargaining table. So thus the fact finder's recommended contract language that's outlined on page 47 of his report is verbatim what was adopted by agreement of the parties and is found in section 4 of Article 15 now of the CBA. So the state's position is that VSEA didn't succeed at the bargaining table in getting the remedy that they seek here placed into the contract language. And Article 15 clearly just allows this board to review the judiciary's classification decisions and determine whether they're arbitrary and capricious. So an arbitrary and capricious decision, as outlined in our briefs, it's one that's arrived at randomly or on a whim, excuse me, without being given much consideration. So, but when a classification decision is based on appropriate classification principles, the board is to give deference to the decision maker, even if the board doesn't agree with the classification itself. So as a result, the board's scope of review in these classification grievances is extremely limited. And so the board doesn't have authority to unilaterally change a position's classification. And the state realizes that the language in Article 15 of the CBA at issue with the judiciary does differ somewhat from the language in the executive branch CBAs, and that's what this board's case law is based on thus far to this point. But overall, the review is still the same when you're looking at an arbitrary and capricious standard and the deference that the board gives to the decision maker. And the grievance has a high burden to show that the judiciary's decisions were not just wrong, but were arbitrary and capricious. But for this board to evaluate whether the classification decisions were arrived at arbitrarily and capriciously, it's also necessary to have at least some understanding of the classification and Willis position review processes. As I think it's obvious, especially if you look at the Willis Guide to Position Measurement, it is a very specific undertaking to do a Willis point system analysis. Most people, I believe probably all people within the state executive and judiciary branches who do the Willis point system analyses undergo training, specific training on this point system prior to being able to actually implement it properly and appropriately. So to that point, nobody is, I don't believe, expecting this board to suddenly become experts on the point system. But I want to give just an overview of the process to familiarize the board. As outlined in Article 15, a person can request a classification review for a position when they believe the position has undergone a significant change that altered its duties and responsibilities. Sorry. The purpose of the classification review, then, is to determine whether the position is still assigned to the proper class. So this is what happened in, for instance, Mr. Crowley's case. Is he submitted a request for review, and his specific position was evaluated by the judiciary. There's also a mechanism for a class action request, which is what happened with the probate register's request. VSEA can submit a class action request on behalf of employees who are all in the same class. So once a request for classification review is filed with the judiciary's human resources manager, he conducts an analysis of the position or positions, if it's a whole class, using the Willis classification method, and then issues a written decision regarding the position's classification. The decision, it says in the CBA, is very clear that the written decision is supposed to specifically lay out the facts that the HR manager relied on and his reasoning in determining that classification. After receiving the HR manager's decision, any party can request reconsideration of the classification decision as step 2 of this process in Article 15. The step 2 request is made to the court administrator's office, and the filing is supposed to articulate the specific reasons the party thinks the step 1 decision was incorrect. Section 3 of Article 15 also mandates that the step 2 filings specify what remedial action is requested, including what class the party believes the position should be assigned to. Then the court administrator or her delegate, in both of these cases, it was the judiciary's chief of finance, Greg Mosley, acted as the delegate for the court administrator at step 2. He reviews the record that was relied on by the HR manager for the reclassification decision at step 1, and then issues a written step 2 decision. In both of these cases, also there was an informal meeting held with all of the parties so that the administrator's delegate can not just rely on the documentation, but also hear from each party directly. It's clear from the contract language in Article 15, Section 3, that the court administrator reviews the classification decision to determine whether it was incorrect, and then can issue a remedy such as assignment to a different class. The final step of the reclassification process is a grievance filed with this board. Step 3 laid out in Section 4 of the CBA, of the Article 15 of the CBA. Here, the language in the CBA is specific that the grievance filing at Step 3 with the board is supposed to articulate the specific reasons the grievant thinks the below decisions at Step 1 and 2 were arbitrary and capricious. The language here in Section 4 is notably different from the language in Section 3 of Article 15, describing the requirement in a Step 2 filing, because Section 3 tells the grievant to articulate the reasons they think the Step 1 decision was incorrect. Section 4 tells the grievant to articulate the reasons they think the Step 1 and 2 decisions were arbitrary and capricious. Also, notably, Section 4 does not invite the grievant to request any specific remedial action. Just like in this case, then the board gets the entire record of the below proceedings, all of the documents and information that was presented to the HR manager and the court administrator's delegate, and reviews the decisions to determine whether they were made arbitrarily and capriciously. If the board determines a reclassification decision was arbitrary and capricious, the state's position is that the CBA does not give the board the authority to impose its own determination of what the proper classification is. Our position is that if the board determines a reclassification decision was made arbitrarily and capriciously, then the proper remedy is for the matter to be remanded to the judiciary to conduct a classification review in a manner that's not arbitrary and capricious. In addition to all the points I've made so far in this regard, I think there's a common sense approach to the remedy issue in these cases, because it makes no sense under these circumstances for the board to be given authority to determine the proper Willis system points value for every position within the judiciary. The Willis Guide to Position Measurement starts on page 89 of the Crowley record and page 787 in Exhibit J of the probate register's case. The Willis system, just broadly, it assigns point values to job components of knowledge, skills, the working conditions, the mental demands such as problem solving, and the accountability of a job, meaning the impact the job has on the organization. The guide goes into detail about the considerations that are relevant for each of these job components, and breaks down the scoring system also into subparts in order to assign the most accurate point values. The total points then assigned to the position ultimately determines the position's pay grade. The Willis system has been used in both the judiciary and the executive branches for many years. And the analysis within both branches is left to those who have a specific expertise in the position themselves and in the Willis review system. So in the CBA for the judiciary, the HR manager is specifically given the responsibility to conduct each classification review for all positions across the judiciary. In the executive branch, which has many more positions to manage, there's a handful of classification analysts who work within the classification division of DHR, and their entire jobs are assigning point values, doing classification reviews, and familiarity and expertise in the Willis point system. And I say this only to emphasize what an undertaking it is to engage in a Willis points analysis of a specific job or a specific job class. So now I would like to talk to the board about the specifics of the cases that these grievances are about, starting with Mr. Crowley's reclassification review.
Ms. Powers?
Sorry?
Could you pause just for a moment for a question?
Hi, this is Judith Dillon. I just wanted clarification. Are you saying that the Willis analysis was performed only by the HR manager, or the HR manager kind of led the process and there was a committee as outlined in the Willis system?
In the judiciary, in the judicial branch, the Willis analysis is only conducted by the HR manager. My understanding is historically there had been committees within the judiciary, but after the bargaining in 2016, pursuant to what's laid out in Article 15, it's just the HR manager who does the Willis analysis for all of the jobs within the judiciary. So to that point, actually, to the extent that the guide to position measurement references just broadly committees and a consensus among the committee members, because in many cases there is an actual committee, in many cases not within the judiciary, but this Willis system is used in many other workplaces and organizations. And many do have committees formed that will have to do, everybody on the committee does their own analysis and then they reach a consensus as the committee. Right now within the judiciary, there's no committees set up. It's just the HR manager who is responsible for gathering all of the information and applying the fact that he's gathered to the Willis points analysis. Are there any other questions before I move on to the cases specifically?
Am I correct, Ms. Powers, in that you cited the executive branch in contrast to the judiciary, in that in regard to the application of the Willis system in the executive branch, there are several managers that apply the Willis factors because the group of employees is larger and more varied?
Yeah, I mean, I guess I don't want to say that that's the only reason the executive branch is set up that way, but there are significantly more employees and positions within the executive branch. And so within DHR, there is a specific classification division that has I think 3 or 4 classification analysts who have the specific expertise to oversee the classification committees that are in the executive branch and to oversee all the reclassification processes that happen in the executive branch. But I think that's a result of just the volume of what they would see in the executive branch versus in the judicial branch. And I only raised that point to emphasize what an expertise is the Willis system requires, because it is just so, it's a very specific analysis that's undertaken. And people, I've personally undergone the training for the Willis system years ago. I've never personally applied it for anything. I just did it for my own education, and knowing that training and seeing the guide that's here, I think that nobody could just read the guide and understand how you're actually supposed to implement the Willis point system analysis.
Just ask, did you just,
Joe, go ahead.
could you back up and repeat what you just said about the Willis guide? Not being able to apply it?
Well, so the Willis guide here, I think it's the Willis guide that is included in the record is very comprehensive, step-by-step of what you're supposed to do, right? I mean, it says like gather the information, apply it to all of these different job components. But then once an analyst or an HR manager is actually going through the process of a reclassification review, this guide tells them how to do the process, but the actual analysis that's undertaken is much more, frankly, thoughtful than, I mean, I know this guide says that it's a thoughtful undertaking and all of that, but it can be very difficult to draw certain distinctions and even just make determinations about what an actual job does, what the job duties of the job are, and the knowledge that's required and the mental demands that are required. Somebody needs to be just very have just a really deep grasp of the job that they're analyzing. So I mean, I can't just look at a job description and apply the Willis factors to a job description, just like in this case with the HR manager, when they took in, there's a questionnaire that when somebody files a request for reclassification review, they fill out this questionnaire and they explain what they consider their job duties to be. And it's not just going through what the job specs say. It's they have the opportunity to talk about everything that they do on a daily basis when they're actually in the courtroom or at the courthouse. And then the HR manager also here would, I mean, he looked at the responses to those questionnaires and everything that was submitted by the incumbents who were seeking the reclassification, and compare it to the job duties, the job description, about what the actual expectations are for the job, but then also go to the supervisors and say, what are your expectations for this job? What do you see actually happening with this job on a daily basis? And there's a lot of information gathering in that way that's required for this. In this case, also the HR manager, I mean, he's just one person who has a really comprehensive grasp on all of the positions throughout the judiciary. So he understands how one job relates to another job and how there might be overlap between two jobs with certain job duties, but what the true purpose of the one job is with the job duty they perform versus what the purpose of the other job performing this seemingly same job duty. And the HR manager has the expertise to draw these distinctions between all the different jobs within the judiciary. And that's a sort of expertise that somebody just kind of walking off the street and reading the job descriptions for all these different jobs isn't necessarily going to understand those distinctions of how all these jobs work together within the judicial branch.
Thank you.
So I'm going to go ahead and talk about first Mr. Crowley's grievance. I think there's probably a lot of overlap between the two grievance processes here. So I'll discuss Mr. Crowley's first. When he filed his request for reclassification, the HR manager reviewed the information that was included in his submission, and he reviewed the job description for the court officer B position, and then he reached out to Mr. Crowley's direct supervisor with specific questions about the job duties of the court officer B position at the Windsor County Courthouse, which was Mr. Crowley's workstation, because there are many court officer positions throughout the state geographically, but what each court officer actually does might depend on their workstation and the courthouse that they are in, because the different courthouses in the different counties throughout the state all see, you know, a different volume of cases and people and things like that. So by doing this, the HR manager was able to evaluate all the job duties that the grievant claimed he performed on a regular basis, and then compare that to all the job duties that someone in grievance position might be expected to perform on a regular basis. And then also get specifics about the particular ways in which grievance position performed those job duties, because the performance of those job duties might differ courthouse to courthouse depending on your work location. So for instance, the HR manager got an understanding of how much of Mr. Crowley's positions how much time was spent in at court hearings, and how many different courtrooms his position covers, the specific details of the different administrative office duties that his position performed, like making copies or requesting documents, things like that. As noted in the job description itself, the core work for a court officer position is characterized as kind of facilitation of the courtroom. They check in people who are scheduled for court, make sure the people go to the right place and have all the documents that they need. They are in the courtroom during hearings, administer oaths, announce the opening of the court session. And as noted, when you look at the step 1 decision that was written by the HR manager in Mr. Crowley's case, a looming factor in this classification review was the ways in which Mr. Crowley's position had changed in response to the COVID-19 pandemic. Courthouse traffic used to be all on foot, of course, and then hearings suddenly just all became virtual in 2020. And so the judiciary's HR manager reviewed all of this and very clearly took all of it into consideration. When you look at the step 1 decision, it starts at page 29 of the record in the Crowley case. The decision notes that although the setting of where the work took place had changed due to COVID, the nature of the work itself didn't actually change. So the grievant was still facilitating the courtroom operations by checking people in who were scheduled for court and administering oaths, and was in the courtroom during hearings to make sure the proper decorum was kept. And this is just that all of this was happening in a virtual setting rather in the physical courtroom. So overall, this meant that the responsibilities of grievance position hadn't really changed. The impact that his job had on the judiciary's operations was still the same. Some of the knowledge and skills that were required to do his job in a virtual setting and the mental demands of his work, some of those had increased, but also some had decreased due to the virtual setting. So when the HR manager applied the Willis ratings to grievance position, on balance, his overall rating wasn't altered enough to show a material change to his position that would constitute a pay grade change. And all of that is thoughtfully and thoroughly laid out in the HR manager's step 1 decision. That's page 20, starts on page 29 of the record. Mr. Crowley grieves the step 1 reclassification review to the court administrator at step 2. And he articulated, just like the CBA says too, he articulated why he thought the decision was incorrect and what rating his position should have instead. And then Greg Mosley, the court administrator's delegate, looked at all the materials that the HR manager had relied on for the classification review, and he met with the parties to hear each side's reasoning for the Willis rating that they each advocated. And then the step 2 decision issued by Mr. Mosley is in section 4 of the record in the Crowley case. It doesn't have a page number, it's just a section 4 tab. And in this decision, Mr. Mosley addresses each point that was raised by the grievant about why the grievance thought the step 1 reclassification decision was incorrect. Mr. Mosley explained for each of these points why he was not persuaded to side with the grievant and find that the step 1 classification decision was incorrect. And also, Mr. Mosley said that the HR manager's reasoning for the point assignments that he assigned was reasonable. So ultimately, Mr. Mosley declared that he was unpersuaded by the grievance arguments, and he upheld the pay grade 17 classification. Mr. Crowley filed this grievance with the board under Section 4 of Article 15 of the CBA. And one of the VSA's arguments is that Mr. Mosley engaged in the wrong analysis by simply declaring that he was unpersuaded by the grievance position. And the state believes that this is misplaced because the step 2 hearing officer was to look at the whole record and determine if he agreed with the grievance contention that the reclassification review was incorrect. So when Mr. Mosley reviewed the record and heard arguments from both sides, grievance arguments didn't persuade him that the step 1 decision was incorrect or that the grievance proposed rating was correct. So now this board is tasked with reviewing the lower decisions and determining whether they were arrived at arbitrarily and capriciously. This board isn't tasked with determining whether the lower decisions were correct or not. It's just whether they were arbitrary and capricious. So, I mean, as detailed in the step 1 and step 2 written decisions, we think it's obvious that the decision makers were thoughtful in gathering the information and formulating their decisions. The HR manager was certainly thorough in his assignment of the Willis point values to the court officer job, and he didn't merely assign points on a whim or without regard to reason, as the standard would require. And then similarly, when Mr. Mosley reviewed the HR manager's classification analysis, he also engaged in a thorough and thoughtful review. He gave weight to all the arguments raised and engaged in an analysis of the job duties and the classification review to the Willis principles. So neither of these decisions, to the extent that the board is reviewing both decisions below, neither was made arbitrarily or capriciously. If there are no specific questions about the review of Mr. Crowley's grievance, I'm going to turn my discussion to the probate registrar's grievance now.
I do have a question in regard to Mr. Crowley's case. When you began discussing Mr. Crowley and his work in Windsor County, I believe it is, am I correct?
Mm-hmm. Yeah.
Do court officer Bs, which I assume is the classification of Mr. Crowley, in different courts in different counties fall in different places in regard to their classification?
So your question is a little too broad for me to be able to answer. Are you asking if they have the same pay grade, or if you're, I'll tell you that if you're looking at a court officer B position in Windsor, if you're looking at Mr. Crowley's court officer B position, his daily job duties, the job duties that he performs on a regular basis at least, will differ from the daily job duties of a court officer B in a different courthouse to some degree. So that would affect the actual point value of the Willis rating, which the points, I mean, the points are hundreds of points, and it's within a range that you fall into a certain pay grade.
So all court officer Bs throughout the state, throughout the various counties in the state, are not necessarily classified the same?
I would say, I believe that they all have the same pay grade, but they might, if you did a Willis analysis of each individual court officer B position, the actual number that you get might be different from one to another.
But that number would not be significantly different such that it results in a different pay grade, or?
So I'm going to answer that kind of broadly about the classification system. And the request for classification review. So as detailed in Article 15, it's when you think a significant change has happened to a position that would affect its classification, that's when you request a classification review. So if you have like 10 court officer B positions that are spread throughout all different courthouses in the state, and you have one of those positions is doing daily or weekly tasks that have significantly changed since its last classification review, maybe 10 years prior, that person can request a classification review, and that position will be looked at. And if the Willis rating of that position shows that there has been a significant change to the job duties of that one specific court officer B position, then that court officer B position would appropriately be reclassified. It might also just be reclassified to be to no longer be a court officer B. It might qualify as being a different job entirely, depending on what the changes were that the job has undergone. Does that answer your question, or just cause more questions?
No, I think it does, in that, in my mind, what you said is that I think Windsor County and the way jobs, or each county perhaps, the way jobs are classified can vary, because the job duties could vary from court to court or county to county.
Yeah, I mean, they won't vary drastically, because if you're a court officer B, there is the list of job duties of what you're supposed to be responsible for. If what you're responsible for on a regular basis is beyond what that list of job duties is, then your job should appropriately be reclassified, and you should request a review.
You might be reclassified as something other than a court officer B.
Correct. That's the thing, I guess, is that if you are doing a job that no longer falls within the classification and job description of a court officer B, then your job would, in theory, be reclassified. Either your job would be reclassified to a different class with a different, like, job specifications and everything, or, well, I mean, that's what the result would be if you'd had a classification review.
Thank you.
Is that really you're not doing the job duties of a court officer B.
Thank you.
Okay, now I'm going to talk about the probate register's grievance. This one was a class action review of all the probate register positions rather than a review of just one position within the judiciary. So to segue from this conversation we were just having, the HR manager wasn't just looking at the one position within one courthouse and the job duties that one incumbent performs on a regular basis. This class action review is, I mean, it's basically the same, because you gather information from the incumbents, you look at the job descriptions, you get the information from the supervisors also, but it's a much broader inquiry. So you're supposed to gather information about, as much information as you can, about all the different job duties that all the different probate registers perform. Which I also will point out, I mean, I think it's obvious in the record here that while there's the one class of probate registers and there's the certain job duties that they are all performing, differs courthouse to courthouse what the specific probate registers actually do on a daily and weekly basis. And so it's important to note again that if somebody isn't familiar with the organizational structure of Vermont's judicial system, there can be frankly great differences between the courthouses in all the counties because the volume and the type of work that's done within each courthouse can vary depending on the population of that county in particular. And the HR manager, I think, noted this in his classification decision, which it's tab D. The step 1 decision is tab D, page 133 of the probate register's record. He said, there are bound to be differences in the actual daily job duties from one probate register to the next. I mean, this is just the nature of a class action review, but the HR manager was tasked with, he needed to synthesize all of the information that he gathered in order to determine what the normal job duties and responsibilities were that universally represent probate registered job requirements across the state. So I think we all know that the record in this probate register's case is extensive. There are many documents to reference when conducting the Willis analysis, but really this grievance comes down to whether the HR manager's classification decision was arrived at arbitrarily and capriciously. And I think the voluminous record here proves that it was not. The grievance disagreed with the step 1 results, and they think that more weight should have been placed on certain job duties or certain comparator positions. The other positions within the judiciary that were used that were placed in comparison to the probate register's positions to make sure that that all these positions kind of fell in line with each other. But I think the point here for both grievances is that it's in VLRB case law, reasonable minds can disagree about how to rate the positions using the Willis point classification system. These grievances are both examples of such disagreements. The grievance provided information and materials that they believed should have resulted in higher ratings than their current position classifications. And the judiciary reviewed those materials and found that no change was required. No change in the pay grade. So the overall points assigned to each position may have changed, but it didn't alter the actual pay grade of the positions. The grievance here have presented arguments about why they disagree with the judiciary's decisions, but haven't actually presented evidence to support a finding that the decisions were arbitrary and capricious. I think VSEA's argument was that the process of developing the facts of what constitutes the job duties was arbitrary and capricious, but that's really what was argued by Attorney Belcher is just a really factual analysis of who said what to whom and what they meant and things like that. It's not appropriate to get into, and the state isn't in a position to provide evidence in this forum where the board's just reviewing the written decisions to determine if they're arbitrary and capricious. The state's not even able to defend the allegations that were made about what consideration was or wasn't given, or how certain people were treated during the process of gathering all the information. I mean, if the grievance had an issue with how management acted throughout this process, I think that's more appropriately handled with a separate grievance. that is grieving management's actions, as opposed to a classification grievance is about the end result of the classification review and whether the classification review was arbitrary and capricious. The classification decisions in both of these cases were based on appropriate considerations under the Willis Point system. The records in both cases show a very detailed analysis performed by the judiciary in conformance with the requirements of Willis that support the correctness of their determination. I mean, overall, the judiciary effectively utilized the Willis classification process that the CBA requires and documented in its written decisions the ways in which the application of the point factor system was not arbitrary or capricious. Reasonable minds can differ, but that alone is not sufficient to indicate an arbitrary or capricious action. The judiciary's decisions and processes in applying the Willis point factor system are detailed, well documented, and were clearly not matters of whim or caprice, which are the attributes of the arbitrary and capricious decisions. And so just in conclusion, for these reasons, the state requests that this board find the judiciary's reclassification decisions were not arbitrary and capricious in either of these cases and dismiss both of these grievances. Thank you.
Questions from the board? No. Ms. Sonnet? Ms. Dillon?
Yes, hi, thank you. I wanted to turn to the judiciary probate registers process. You did not indicate, or were there incumbent surveys distributed? Was there a request for the probate registers themselves to actually complete surveys? And did they complete surveys?
So my understanding is the surveys, like, or questionnaires, whatever they are referred to as, that is the first step in the process to initiate an RFR. So there's a form that employees fill out and file with the HR manager. And the form itself is, they are in the record. Good grief, though. Don't know that I'll be able to tell you easily where in the record. But I think it's part of the original submission, maybe starting in tab B. It is the first step to initiate the request for the review is, as Article 15 says, they submit a written request for a classification review, and the request is submitted to the HR manager and consists of a form that contains certain things, including a statement of the facts upon which the applicant's request is based, which would be articulating what the significant changes are in their job duties, and then also any documentations that would support the reclassification. And in this case, I think in the probate register's case, the original filing of the request for reclassification included 70 pages of documentation to support it.
And is that, where is that in the record? And if you don't know now, if you follow up, that's fine.
Maybe C.
So yeah, I think it's tab C. I think tab C contains, I guess maybe Tim would be able to speak to this better about what is in tab C, but I think that was the original submission that initiated step 1 of the RFR for the probate registers.
Okay. Yes,
Okay.
tab, the first 127 pages. The first tab, yes, tab C is the initial submission. Described
Thank
as
you.
that on the table of contents, it's under tab A.
Yep. Thank you. And another question is in terms of the survey of COMs. All of the COMs were not surveyed for all of the counties or applicable courts. And you've indicated that each court is different and each county is specific and some are larger than others. There are a number of counties that weren't included in that survey. So the CAMs didn't include some of the, didn't include, for example, Chittenden County. How does that adhere to the Willis methodology or Willis principles?
Well, the Willis methodology doesn't require surveys of the managers, first of all. But also the surveys or questions were sent out to the managers who had the most experience overseeing probate register positions. And I believe also, I mean, I can get back to you with a more thorough answer, but I believe not all managers who were solicited for feedback chose to provide feedback and input about this. And which, like the judiciary can't make them provide feedback, but they can request some feedback and they take what they get.
And the decision after getting the number of responses that they got to not conduct interviews or elicit additional information, what was that based on?
Well, I think that that's more of a, I feel like that's getting a bit into more of a factual thing that would be proper for submission of evidence for you to hear from the decision maker directly. But my understanding is that the HR manager had a good grasp about what this position does and felt that he had plenty of information to be able to engage in the Willis point system analysis. Like there were no open questions still in his mind about what job duties were performed.
Okay.
So no follow-up was needed.
And how, and again, this is in terms of the job duty description and the actual jobs performed, there are at least one, if not two jobs that the probate registers do not perform. Where in the record is that accounted for or reflected? For example,
Can you repeat that?
Or one of the factors looking at the Willis system, you look at what the job duties are. The job duty listing for probate register includes at least one job duty related to jurors or juries, and that's not applicable for probate registers. The analysis or the evaluation or the discounting of, did that impact the analysis? And if so, where's that reflected? Or
So I think my response to what I think you're asking is that a classification review is based on the job duties that positions do perform, as opposed to determining whether or not a job position does perform all of the duties listed in a job spec, for instance. So like in the example you just gave, if there's a job spec that lists a job duty that it turns out the people in that class don't actually perform that job duty, That to me is more of an administrative thing that they should change the job specs to just delete that job duty. The fact that they don't perform a job duty that is contemplated in the job specs doesn't count against them in the review. The review is really just tallying up building points based on the duties that are performed.
All right, and I have a question that is actually for one or both of you. And so looking at Article 15, and let's use the probate register as an example. Paragraph 2 indicates that the classification methodology for the judiciary will be based on the Willis classification system. And then looking at further within that, on page 897, it provides that requests shall be submitted to the human resources manager. And then the second to the last paragraph in paragraph 2 is that the human resources manager or his or her designee shall conduct an analysis of the position or positions that are the subject of the request. And this might be a question for Mr. Belcher, but did the union agree to having the human resource manager being the sole person involved in the Willis classification review?
I think we understood that it was going to be his prerogative to control that process. Whether he did it personally or whether he did it with a committee, I think is up to him. But I think that we understood that rather than have a committee that we thought was really controlled by him anyway, that it would make sense to mimic what happens in the executive branch, where management makes the initial determination. Since I'm on that, I just would say that the difficulty with translating that to the judiciary is that in the executive branch, the HR classification division is somewhat separate and insulated administratively from the kinds of normal pressures that you would have, and allows them to, I think, apply the system fairly neutrally. We often have problems with what happens. We often think that the departments are, exerting undue influence, but it is a group of professionals who we respect and who, and it may be helpful to think about for the judiciary to think about whether they need some other managers involved in the system to make it, to give it that kind of a broader legitimacy. But we agree that the HR manager is allowed to control the system at the initial step.
Thank you. Thank you.
Excuse me, Ms. Powers, you in discussing the application of the Willis system again to job duties, you mentioned job duties that were universally represented among the probate registers scattered throughout the counties in the state. Does that, to my mind, that might necessarily lead to a lowest common denominator result if the job duties have to be universally represented. Is it the case that there has to be congruence among the job duties?
No, I understand.
Just
Oh.
froze.
You just froze, Ms. Powers.
Been a bad question.
Attorney Powers, if you could hear us, or maybe Ms. Tewksbury, you can ask her to maybe leave and then come back again. We've had success when people do that after freezing.
Could we maybe take a 2-minute break? Since we've been at this
Probably
for
is
2 hours.
appropriate.
Good idea.
That'd be great. Thank you.
Thank you.
Why didn't we
Hi, Judith, if you're there, I'm back on Teams,
can
but on
hear
my
you.
phone. Okay, I'm on my
Okay.
phone, so I'm gonna keep
That's-
I'm using like the data.
Okay,
It doesn't seem to be a Wi-Fi issue. I wasn't able to get on back onto Teams on my phone or on my computer, so I'm restarting my computer, but at least was able to join you here.
okay. Thank you. We're just taking a brief break and we'll be back shortly. So if I think Mr. Belcher will be comfortable with your appearing just by voice. This is oral argument, so it should be okay. But we'll be back shortly.
Okay, and I'm
Attorney
restarting my
Bel-
computer, so it might all
Okay.
resolve itself with that. I don't know.
Great. Attorney Belcher, Attorney Powers right now is able to get back on by phone. She's going to try again with her computer and we'll be back in just a few moments. Okay, thank you.
Let's see if she remembers my question about the lowest common denominator.
Okay, we're back.
We're back on the record.
Gosh, I'm so sorry, everyone.
Ah, well done to get back. So you were about to ask my question about how a lowest common denominator result is avoided when there's only a limited scope of job duties that's universal under consideration.
Yes. So I guess, first of all, it's not just that the classification is, or the points are based on only the job duties that all probate registers perform. That's not what I meant by universal. I meant universally means looking at all of it, not only job duties that are universal. So it's, but there is, I mean, it's in some ways, I don't want to say it's a consensus, but it's that because there are differences in the actual daily job duties from one probate register to the next, the HR manager was needed to determine what the normal job duties and responsibilities were that represent generally probate register job requirements across the state. So in that, I mean, in the same way that you wouldn't, if you have one probate register in one county that's doing certain job duties that no other probate register is doing, that are job duties above and beyond what any other probate register is doing, that whole class doesn't get reclassified just based on one position performing outside the scope of the class, if that makes sense. So at the same time, so it's looking at what the normal job duties are across the state for all probate registers, and it's not just so you'll have a probate register in one county that doesn't do certain things, but but they still get the benefit of a classification for a class that does include certain job duties that even that person doesn't perform. So it's similar to like Ms. Dillon's question about the jury job duty that's in the probate register job description. If just because one probate register isn't doing that job duty doesn't mean the whole class is kind of like brought down in its rating because the one position isn't required to do that job duty.
Is it
Does
perhaps
that-
more, is it more appropriate for me to think of this as a bell-shaped curve of job duties?
I think that is a very appropriate way of looking at it, yeah.
Thank you.
Also, in the interim, I was able to kind of narrow down in response to also going to one of Ms. Dillon's questions about the questionnaire submitted by the probate register. So we said that the original submission of 70 pages to the HR manager, but it was in the first part of that is the questionnaire, the description that was submitted by probate registers themselves. With their submission, it's like, I don't know how many pages it is, maybe 16 pages of answering questions and giving narratives about their job duties.
So just to clarify, it's starting, I guess, page 42.
Yeah, I mean, I think that the form itself technically starts at page 41, but that just has instructions on it.
But the response, 42 through 59, and it's signed by 13 probate registers on page 59. Is that what qualifies as an incumbent survey?
Yeah,
Or is that what
so without looking at all like 900 of these pages, I don't want to say that there's absolutely no other written input or survey questionnaire answers in the record, but that is what was originally submitted as the response to questionnaires.
Okay, thank you very much. And one more question regarding the probate registers and the survey sent out to supervisors. If some of the COMs are not focused or don't have any day-to-day oversight of the actual work and the substantive work that's done in the probate court, was it appropriate or was it necessary for the HR manager to survey or contact the probate judges who do have a direct oversight and contact with the substantive work that's performed by the probate registers?
I mean, the state's position is that it's not appropriate. That's never been how it's done. And I want to also distinguish that the judges there don't have oversight of the probate registers. They come into contact regularly with the probate registers, but it's, I mean, there's no, I mean, if you open the door to start surveying, you don't survey people's colleagues to find out what the people do for their job, and the judges don't actually have oversight of the probate registers, so it was not appropriate or necessary to survey them.
And and perhaps oversight was the wrong word, in terms of that they actually see and review and rely on the work and the input of the probate registers. For example, how they actually input information into Odyssey and how that information's received by and used by the probate judge in performing his or her work. So the probate judge.
But
Actually-
job duty is to input information. That is the job duty of the probate registers. How the information is used by a probate judge is not, it's not necessarily to do a survey to find out how the probate judge uses the information. It's the job duty of the probate registers gathering the information, and also what the judiciary's expectations are of a probate register's position, and what the probate registers are supposed to do as job duties.
Maybe I'm not making myself clear. I wasn't asking for the probate judge for information on what the probate judge does with that information, but it's the probate judge who actually sees how and what information is inputted by the probate register. And it's they who know whether the information and what information is put in, whether it's put in accurately, and the importance of that information, as opposed to
Right.
a COM who's working in the superior courts, family, criminal, civil court.
But what you're talking about is an individual's performance within their job and how well they do their job, which is not a factor in the Willis Point analysis. I mean, if, doing a performance evaluation for an employee, if you want to do a 360 review and talk to the judges, that's a whole different thing. It's a completely different process than a classification review.
Thank you.
Chance for rebuttal. Mr. Belcher, an opportunity for rebuttal.
Yes, thank you, Mr. Chairman. Let me start with the allegation or discussion about the fact finder's report and remedy. At page 38 and 39 of the fact finder's report in Q is the key point, that the paragraph where he discusses that the union's request for de novo review is something that's not in the executive branch contract. He never in that paragraph mentions remedy. He doesn't talk about remedy at all. So that was one difference we have with the characterization. Again, it may make sense to just brief remedy when we get to that point, if we get to that point, but I do think that that's important. There was a question early on about if there are added duties to court officer B and what would happen, and that's exactly what happened to the other position that we refer to, and that there's records about in the court officer B case, and in Mr. Crowley's case, there was another job, another position, another court officer who was handed a bunch of responsibilities related to Odyssey, to WebEx, other docket clerk or judicial assistant jobs, and was reclassified into a different position. And that's what's appropriate to happen if you find a single job within a classification that has somehow broken away from the rest of them with additional duties requiring higher pay. And on the probate register side, that's what would justify if there is a substantial difference between probate registers, so that some do write orders and draft things for the judge and some don't, then it would be appropriate to reclassify and upgrade the ones who do. It's not a question of dragging everybody down to a common denominator, which is exactly what the court manager, the HR manager did in this case by only looking at some surveys from supervisors. We disagree that you can't look at the whole process, and that somehow we need to now file a different grievance to allege that the process leading up to this, to the final calculation of Willis points, was somehow arbitrary and capricious. No, the entire process has to be done in a way that's not arbitrary and capricious, and we can challenge the result based on the flaws, I think, that are well documented in the initial process. The fact that the judiciary has negotiated to give up its right to have a full hearing to defend itself, they can come back to the bargaining table and ask for a full evidentiary hearing on these cases. We'd be happy to look at that. But since they've insisted on a de novo review of just the facts, if they've acted in an arbitrary and capricious way in the way that they've handled the case up to now, we get to present those facts as best we can, and we've done that. And so we would completely absolutely reject the notion that they can effectively cheat, in our view, at the earlier steps of the process, and that somehow we can't reach that. We agree, though, that if they want a full evidentiary hearing on how this is done, that would be better. We'd love to be able to cross-examine Mr. McGlynn. We'd love to be able to depose the supervisor who was told that she could be replaced by somebody at McDonald's, and understand really what was going on with all of that. The initial filing of the request for review is sort of like a complaint. It's an initial document that's done by, in this case, by a group of them who put it together. It is not a survey and is not a substitute for a survey. The survey has a separate purpose, which is to identify exactly those distinct individual differences in how the job is performed throughout the system. They never did that. They never asked every single probate register, and they really didn't even ask Mr. Crowley specifically, what do you do on this point that's important to us? They didn't figure out which ones of these people do write decisions and orders and provide other legal advice. They didn't figure out the details of exactly what's involved in working with Odyssey. Those are the kinds of things that are supposed to be elicited from the employee through some kind of first survey or through an interview. It's supposed to come from the employee, though, himself or herself. It's not supposed to come from the HR director's supposed understanding of every single job that's out there. He just does not know that. And the whole point of this Willis system is to get away from having those kinds of compensation decisions based on perceptions by high-level managers who really don't understand. The comms, the court operations managers, and the clerks have, on paper, supervisory authority over these employees, but they do not work in these areas, and they frankly don't understand this work. Some may understand it better than others, but the people who understand what the probate registers do are the judges. And they were completely cut out of the process because they were going to be supportive of these employees. I would submit based on that we're not looking at a question of whether it's a bell-shaped curve, because there could be high-level duties that are at that are outside of that, the high point of the bell and of the curve, and that that are significant, regular, and that even they may or may not be done by everybody, but that are regular parts of the job that that should be considered. And the Willis system looks at requiring that the analysis be focused on those higher level jobs, level tasks, so that the evaluation of mental demands and so on really reflects what's needed to be able to perform the work. I think that's I know certainly there are plenty of points of disagreement, but we've covered it in the covered a lot of ground in the 1,000 pages of documents we've given you, and the 50 pages of briefs and presentations today. So unless you have questions, I'll stop there.
Thank you, Mr. Elser. Ms. Powers?
Thank you. The state rests.
Thank you. Give us a moment, please.
Allison, do you need a color-coded version of the spreadsheet? I can mail it
No,
to
I
you.
have the electronic.
Okay.
Which I think is color coded.
Do we have? Yeah. Okay. Just a reminder regarding Exhibit Q that we're going to get a color-coded hard copy. G, Exhibit
Yes.
G, yes, color-coded hard copy. Without anything else to come before us.
Actually, we'd like 4 copies.
Yeah, right. Okay. Yes, no, I got that. I figured that. Thank you.
We're finished for today.
Thank you very much.
Thank you all for your time.
All right. Thank you all. Yes.
Thank you.